Okay, good afternoon again to everybody, both on behalf of the Elisabeth Käsemann Foundation and on behalf of the Memoria Legal Working Group. I am honored to present this second Memoria Talk. We will have today 2 speakers from Argentina and 2 speakers from Germany who will refer to us and lately discuss about a topic that is very, very present nowadays in both countries. It has its history, but it's current more than ever. That is the principle of universal jurisdiction. I would like to introduce first our moderator. He is a member of our group, Memoria Group. Boris Burgard is a professor of criminal law, contemporary legal history, and philosophy of law at Philipps Universität Marburg in Germany, and he's the author of many, many academic articles, book chapters, papers on a variety of topics. And today he's going to be our moderator in order to present each of the speakers and conduct the questions and answers at the end of each panel. The first introduction before the panels is going to be under the supervision of Alberto Zuppi, who is another member of our Memoria Legal Working Group and an expert in Argentina and globally on universal jurisdiction, also professor of criminal law and particularly international criminal law. So Boris, if you want to go on, please.
Thank you, Natalia. So a warm welcome, bienvenido also from my part. As Natalia has said, I'm taking over the moderating duties. I mean, Natalia has already given more or less the introduction of our first speaker, who is also a member of our Memoria Legal Expert Group, Alberto Zuppi. He will give a short introduction to the principle of universal jurisdiction, which is, of course, the topic of our event today. Let me so just add a few words on Alberto's curriculum vitae. He is one of the most accomplished experts of international human rights law and international criminal law. One can imagine he is a lawyer by profession and devotion. As many of you are aware, he was involved in bringing to court perpetrators of international crimes of the Argentinian dictatorship. And as an academic, he holds a PhD from the Universität des Saarlands in Saarbrücken in Germany. He held the chair of Robert and Palmer Martin Professor of Law at the University of Louisiana and is currently a professor of international law at the Universidad de Buenos Aires and also the Universidad de CEMA in Buenos Aires, Argentina as well. Alberto, we are very happy to have you, of course. Maybe just for on organizational matters, we would like to ask you to write your questions into the chat. I guess you all are all aware of the function of Zoom. So we can bring them into our discussion. We will have a first discussion after the presentations of our first panel. I will introduce the panelists to you later. So now, Alberto Zuppi, please take the floor.
Thank you very much, Maurice, and well, welcome to everybody. I'm very pleased to make a very, very brief introduction to the subject of this meeting, a matter that has been concerned for most of my life as a legal researcher, as you know. My country, as you must know, has been subject to different dictatorships, and the fight for removing immunity from those who have committed crimes against humanity was a crusade that many human rights workers have been engaged for decades. Thank God, that time is behind us, but not in other parts of the world, as you must know, that happen in every place of our planet. The fight for suppressing immunity from those who were involved in international crimes know only one limit in time: the passing away, the death of the last perpetrator of crimes that occurred decades ago will put an end to the criminal prosecution of those offenses. I'm talking about the criminal prosecution, but not the civil responsibility. Then will remain only from the victims the chance to request a civil reparation. Nowadays, there is no other limit for punishing international crimes. As we are aware, we know 4 kinds of means to have jurisdiction, criminal jurisdiction, in the case of any offense that has an international meaning. First, what we know as personal jurisdiction, that could be active or passive, whether we talk of the nationality of the perpetrator or the nationality of the victim. Second, the territorial jurisdiction also could be active or passive, whether we refer to the place where the crime begins or where the crime is finished. The third kind is called ubiquity jurisdiction, and it's better perhaps to explain to those who doesn't know criminal law with an example. It is a funny example, as a matter of fact. Suppose that some mad people in China decide to produce fake Argentine pesos. As you know, we have a very strange economy and our pesos are very devaluated. For that reason, I'm calling these people mad. But in any case, all persons involved, authors, dealers, users, and sellers of the fake pesos are Chinese. But Argentina will have jurisdiction because one of its vital interests, its currency, is being fake. This is the third kind of jurisdiction. Now to the last one, and is the subject of our meeting here. Although in November 1998, it was brought to the public attention when a Spanish judge requested to the United Kingdom the extradition of Pinochet, a dictator for crimes against humanity perpetrated in Chile, this last kind of jurisdiction is the oldest known by jurists. Already Cicero talked of communis hostis omnium, enemies of the mankind, referring to the pirates. All countries around the world could be interested in the prosecution. This is universal jurisdiction, that any country could prosecute for a crime committed abroad. I'm pleased to see the renewed interest in the subject by the world community to stop international crimes and relieve its perpetrators from any possible immunity. Then, as I said, this is the topic of our subject. This is a very brief meeting, and without other introduction, I welcome our high regarded speakers. Boris, your turn.
We cannot listen to you, Boris.
Sorry about that, of course. Thank you so much, Alberto, for setting the scene. So I will now introduce you to our speakers of the first panel, which will provide us with the Argentinian perspective of current issues and problems of the principle of universal jurisdiction. And our first speaker is Alejandro Käsemann. Alejandro is professor of law at the University Torquato Di Teja, and you may very well know him as the author of The Philosophical Foundations of Extraterritorial Punishment, published by Oxford University already in 2010. I was surprised to see that it has already been 14 years. It is surely one of the best works on the philosophical foundations of international criminal law, which is also one of the particularities of Alejandro's work on international criminal law, that he has always a strong theoretical approach, philosophical approach to these issues. He has published in leading journals of international law as well as legal theory, namely the European Journal of International Law, Leiden Journal, and the Journal of International Criminal Justice. And I have been told that he is currently working on a book on a theory of asymmetrical conflicts. Of course, also a highly relevant subject of international and international criminal law today. Alejandro, we are so happy to have you here with us, at least for the next 40 minutes, because Alejandro is also serving now as the dean of his university, and he has duties to attend at German time, 6 p.m. So this would be, if I'm not mistaken, 1 p.m. in Argentina. So we have a limited time only with Alejandro. Please, the floor is yours. Alejandro will give his presentation, his short input. Then we proceed with Julieta Mira, and then we will have time for questions to both of our first speakers. Alejandro, please.
Thank you so much, Professor Burkhardt. Thank you also to the organizers, to Natalia and Alberto. I'm very, very thrilled to be part of this conversation. I have been asked to talk a little bit about universal jurisdiction in Argentina and the broader Latin American context. So I'm going to tackle four discrete questions. One is about the tradition of international law and the legal traditions concerning international law, and particularly international interventions, legal interventions in Latin America. Then I want to present a brief, though hopefully interesting scenario about what's going on in Latin America, and in particular in Argentina, and universal jurisdiction. And then I'm going to talk about why this may have happened, particularly the Argentine case, and why we should care about it. So historically, Latin America, as everyone well knows, comes from decolonization in the 19th century, and had to fend off imperialistic drives by several European countries. So the core sensibility in Latin America revolved around two big notions. One is the principle of non-intervention, and the principle of sovereign equality. So if we look at the specific developments that Latin American international law has construed during the 19th and most of the 20th century, the Calvo and the Drago doctrines in Argentina, the Estrada doctrine concerning recognition of governments in Mexico, the Montevideo Convention establishing the conditions for the existence of a state, the work of Isidro Fabela, and many other Latin American jurists of the 20th century who were particularly concerned with this sensibility about fending off external intervention. Now, at the same time, many Latin American countries, and this is particularly acute in South and Central America, experienced gross human rights violations during the 1970s and 80s. And through that, they developed many transitional justice mechanisms, including not only truth commissions and truth mechanisms, but also perhaps an unparalleled emphasis in accountability for gross human rights violations and crimes that it's unparalleled in anywhere else in the world, starting with the Junta's trial in Argentina in 1985, as the movie has now made quite well known. but also to going all the way to the special jurisdiction for peace in Colombia after the peace agreement with the FARC, but also Peru, Chile, and Uruguay, and several other countries have turned to prosecutions for human rights violations. So within this tradition, it is notable that during the last 20 years, at least 12 states in Latin America have enacted specific provisions on universal jurisdiction, mostly on the basis of conventional obligations, but also sometimes under customary international law with specific references to piracy, as Alberto was mentioning earlier, or slave trade. So Bolivia, Chile, Costa Rica, Cuba, Ecuador, El Salvador, Honduras, Mexico, Nicaragua, Panama, Paraguay, and Venezuela now have specific provisions in their criminal codes establishing universal jurisdiction over certain international crimes. One can trace some of these developments to geopolitical interests, war on drugs, the war on terror, and most recently the fight against corruption have been invoked repeatedly as reasons for this type of provisions. Notably, though, only very few countries have used these provisions. As of 2020, which is the last big database we have developed by a colleague of mine, Maximo Lange, at UCLA, there were only 5 investigations in all of these countries, including 3 in Chile, 1 in Brazil, and 1 in Colombia. Now Colombia has a few more. But that's surprisingly, well, perhaps not surprisingly, that's not a particularly strong approach to universal jurisdiction in the region. Now, in this context, there's a notable, a remarkable outlier, which is Argentina. Argentina did not legislate on universal jurisdiction over the last 20 years, and yet it has more than 100 cases filed on universal jurisdiction grounds, some of very high profile, including a case on genocide for genocide in Myanmar, a case against Chinese leaders, including Xi Jinping, a case against Mohammed bin Salman of Saudi Arabia, a case against Álvaro Uribe, the former president of Colombia. And now I understand there's a plan, an initiative to initiate a criminal case against Hamas leaders for their attack of October last year. So in terms of numbers of files initiated, Argentina is the 7th country in the world after, of course, Germany in the first place, but also most of the other countries in the top 10 jurisdictions are of the global north. In fact, the second country from the global south, whatever global south means now, is South Africa, which only 7 cases initiated, and it's on the 17th place. So this is very unusual. I think it calls for an exploration. I don't know whether I have an explanation for this, but I have an explanation. Now, it's also interesting to note how this development came about. Because, as I said, there was no specific legal provision, so this had to be done strategically by NGOs and the judiciary working together, let's put it that way. So there was a complaint against Spanish officials for crimes committed during the Franco regime in Spain, which was originally rejected by the first instance judge. We have a continental system, which we have a mixed procedural system with investigatory judges and then oral criminal trials, which are more adversarial. But the first part of the proceedings in Argentina is more inquisitorial. And so the first instance judge rejected the complaint and said, "Oh, sorry, I don't have any jurisdiction over Spanish crimes." There were private prosecutors, we call them querellantes, and together with the prosecution office, they appealed, and the appeals chamber decided on the basis of access to a court provided in Article 25 of the American Convention of Human Rights, that Argentine courts should open the case and should investigate these type of offenses. Later on, Argentine judges realized that we do have in Article 118 of the Argentine Constitution, a particular provision that could be read as providing Argentine judges with universal jurisdiction over international offenses. This provision states that it talks about trials in general. It says, and I quote, "The trial shall be held in the province where the crime has been committed." And now this is the relevant part. "But when committed outside the territory of the nation against public international law," notably the Spanish version speaks about the law of peoples, derecho de gentes, not international law, but the more or less official translation in the Argentine Congress talks about a crime committed against public international law. Then it says the trial shall be held at such place as Congress may determine by a special law. And the Law 14, which organized the federal justice system in Argentina, establishes that these crimes shall be prosecuted before federal courts. So Argentina had a provision that comes from its 1853 constitution. This provision largely comes from Article 3 of the US Constitution and Article 117 of the Venezuelan Constitution of 1811. And it was only recently and after the fact read as providing Argentine courts with universal jurisdiction over international crimes. Now, as I mentioned earlier, Argentina is also a continental legal system that provides for mandatory prosecutions. And then once the Argentine courts realized they had universal jurisdiction, then another problem came, which is how to limit this universal jurisdiction in a country which, as I said, has mandatory prosecutions, which means that prosecutors and investigatory judges need to prosecute every criminal complaint they receive. And the mechanism to modulate this type of prosecution also was created, in a sense, by the judiciary working hand in hand with NGOs, but in this case, with an original idea. So, well, I'm not sure how original it is, but originally within the Argentine legal system, because it has no legal backing. So, a few years ago, when Argentina was organizing the G20, Mohammed bin Salman, the Saudi prince, was coming to Argentina, and also at the time he was the Minister of Defense, and an international NGO, Human Rights Watch, presented a criminal complaint against him, and the judge, having to decide what to do with the criminal complaint, acknowledged that it had jurisdiction, but it determined that in order to be able to exercise that jurisdiction, it should check whether the same facts were being investigated elsewhere. In other words, he determined single-handedly that the Argentine universal jurisdiction was subsidiary to any jurisdiction by a country which had a more direct connection to the crime, going back to Alberto's initial presentation about the different jurisdictional bases. So if a country has territorial jurisdiction or jurisdiction based on the nationality of the offender or the nationality of the victim, then Argentina would not be entitled to, I mean, we can construe this as an admissibility claim. And on this basis, Argentine judges have been able so far to fend off the more politically sensitive claims on universal jurisdiction, such as the one being requested against Chinese leaders. So there is much of legal innovation within the Argentine legal system that has allowed for universal jurisdiction to flourish in such a way. Now, the question is, why did this happen in Argentina and not in Colombia, Chile, Uruguay, Brazil, Mexico, or any other Latin American country? Now, one preliminary idea I would throw here is that this sensibility about non-intervention and sovereign equality has receded over the last 20, 30 years. There's a different canon, a different sensibility that is dominant within international law, and I've seen this firsthand. We're editing a book on Latin American international law that will come out possibly during this year, with 30 essays by very prominent Latin American international lawyers. And we find out, I mean, my colleagues, my co-authors and co-editors and I, we find out that there's a different sensibility that's not so much concerned about non-intervention as it was before, but rather on using international law for specific purposes and specific goals in Latin America. So the main sensibility that was predominant in the 19th and 20th century against intervention is receding. But of course, this is not a particular explanation. A second argument why Argentina in particular is because Argentina has been on the receiving end on universal jurisdiction cases, particularly in the 90s, where the amnesty laws were enforced in Argentina, and before they were declared null and void, and they were very much instrumental in helping create the political momentum for invalidating those amnesty laws. So Argentina has a positive experience being on the receiving end of universal jurisdiction. And the Pinochet effect, as was mentioned by Alberto, I think was also relevant. A second element, which I think is, or a third element, which I think is relevant here, is that Argentina has private prosecutions. This querellante figure, which allows NGOs and legal experts and people like Alberto and other experts from Argentina and from other parts of the world who give legal grounds and legal justifications for courts to proceed with these investigations. And when, as in the Spanish case I mentioned at the beginning, courts are not willing to do so, they insist and they go on appeal and they seek accountability. Third, I would say that so far it's not been particularly costly for Argentinian authorities that its courts recognize this universal jurisdiction. And I think this is crucial because, as we've seen in other places, most notably Spain and Belgium in the late 90s and early 2000s, when it becomes too costly for a country to prosecute on the basis of universal jurisdiction, that possibility is rapidly curtailed. And finally, I would say that one element that I think is critical is PR on the basis on the part of judges. So federal judges in Argentina, and particularly federal judges in the city of Buenos Aires, are a very controversial figure. They're very powerful figures. They're on the media all the time because they have all the big corruption cases, and of course, because corruption cases in Argentina do not necessarily or often lead to convictions, their PR is always or usually quite weak. So in these kind of cases, they finally have an opportunity, without confronting with the Argentine political class, of making some requesting some goodwill of the public in general. And so I think that this is a particularly important element that explains why Argentinian judges are so keen on opening these kind of cases. There's another element, which is that because we have prosecuted these type of cases in Argentina, I mean, very complex investigations involving international crimes, several perpetrations, and often hundreds of victims, they have the know-how. The Argentine legal system has the know-how about how to go around these cases. So let me close with why I think this matters, because there's another element which is critical for the Argentine experience, is that although we have opened more than 100 investigations, we have had no trials. And we have had no trials because we cannot get any defendants. We cannot get a hold on any defendants. We have issued arrest warrants in some cases, but none of them has provided us with any defendants to face trial. And because we don't have trials in absentia, at least so far, there's no trials. And the question is then, why should we care about universal jurisdiction in a country that cannot enforce any decisions? And I will give you at least two important answers to my mind. First, because an arrest warrant in this kind of case, or the opening of an investigation in this case, has a very strong communicative force. So Human Rights Watch was very pleased that Argentina had considered opening an initially opened the investigation against Mohammed bin Salman, even though it was unlikely that it would lead to his detention and prosecution, because that allowed them and allowed many other organizations to put the crimes they were trying to make everyone aware of in the cover of many newspapers all over the world. So even though we don't reach the conviction stage of a trial, these prosecutions have a very strong communicative power in terms of highlighting the offenses and the responses. And second, and this has been the case in the Spanish investigation, but also in the Rohingya genocide investigation, it gives a forum for victims to tell their stories, express their grievances, and a place for the construction of memory. And this is very important for victims. So victims are grateful and are engaged and are very much involved in these processes because it means so much to them. So although we don't have convictions, although we don't have even trials, I think this process has provided many of the stakeholders with important benefits that I think are worth the trial. I will leave it at that. Sorry if I went over a couple of minutes. Thank you so much for your attention and for the invitation.
Thank you so much, Alejandro. Yes, indeed, you have put me in a dilemma, so to speak, because now I have to decide whether we allow questions to your presentations. But I think we should indeed proceed to our next speaker and the second input from the Argentinian perspective, which will come from Julieta Mira, who is an adjunct professor of human rights law at the Universidad de Lanús. And more precisely, she's a researcher at the National Scientific and Technical Research Council at the Institute of Justice and Human Rights of the National University of Lanús. Julieta is both a social scientist and a lawyer by profession. She holds a PhD in social sciences, and she has also strong ties to Germany. She was a fellow for the Rosa Luxemburg Stiftung at the International Research Group on Authoritarianism and Counter Strategies, and she has been a visiting scholar to the Leuphana Universität in Lüneburg and also the University in Freiburg. Julieta, please proceed with our second input. The floor is yours.
Thank you very much for your introduction and invitation. I'm very happy to be here and with the opportunity to dialogue with my colleague, with Alejandro Käsemann. Well, I will start with an idea of the nowadays information related to this proceedings in Argentina, because in the last few days, several events in our country have shown that universal jurisdiction cases are still running and alive. And what does it mean that a legal phenomenon is driven? What makes these particular criminal cases alive in a country from the global south and also under crisis? To answer these questions, I will share some aspects regarding the judicial developments of some criminal cases for international crimes currently under trial in the Comodoro Pi courts. Please, David, you can show the follow picture. Yes, this is the building, and inside there we have these proceedings in Buenos Aires. The first one refers to the investigation of genocide and crimes against humanity alleged committed against the Rohingya people in Myanmar. Please, the following. In the years 2012 and 2018, on June 28 this year, the federal prosecutor Guillermo Marijuán presented a request for an international warrant to arrest 25 defendants including the chain of command of the armed forces and the main political leaders at the time of the event. Please, the following. Okay, here a victim, a complainer, and the lawyer, Tommaso Quintana. Please, the following, David. Yes, okay, and this is part of the text with the request for an international warrant, and this is the list of the people of, okay. And the following? Okay, thanks. Okay, the second one concerns the alleged international crimes committed in Venezuela in the context of the persecution of political opponents during the government of Nicolás Maduro. In this case, by the end of June, also this year, 2 witnesses arrived at the Comodoro Pi court to testify in hearings. On that occasion, the prosecuting lawyer, Ignacio Hoptis from the Cluny Foundation for Justice, told the press that it was a historic event. Please, the following. Okay, Nicolás Maduro, and the other one. Okay, here we have some of the sense of the facts and the lawyer. Okay, and the following, please. Thanks a lot. Well, the third case is related to the so-called false positives or summer execution of youth in Colombia, perpetrated during 2002 and 2008, and on July 1st, also this year, Judge Sebastián Ramos decided to accept the plaintiffs, both human and legal, in this case from 3 institutions from Colombia: Corporación Jurídica Libertad, Fundación Comité de Solidaridad con los Presos Políticos, and Colectivo de Abogados y Abogadas José Alvear Restrepo. All of them had complained about these cases and claimed the responsibility of former President Álvaro Uribe Vélez. This is an unprecedented event, as the Special Jurisdiction for Peace, JEP, from Colombia does not have jurisdiction over former presidents, and there are no open investigations before the International Criminal Court. The following, please, the next one. Okay, Uribe, the former president, the next one, please. And here we have victims, human rights advocates, lawyers, and this picture was taken in the Mother of May Square demonstration every Saturday. So it's the connection with the local movements of human rights. And the next, please. Okay, and here is the moment of the submission of the complaint. And this is in front of the building of Comodoro Pi. And again, we have members from human rights organizations in Argentina, the lawyer, and other people from Colombia. Okay. Okay, thanks. And no, please, the previous one. Okay, that's it. And this also, again, members from Colombia connected with the complaint, and mothers from the May Square. And okay, so again, the solidarity between the movements and the struggles for justice. Okay, these are judicial events of varying magnitude, but all of them show that the proceedings initiated under the principle of universal jurisdiction in Argentina continue, besides the complexity of this kind of proceedings, also in the current local political scenario. This is an ongoing experience that has been fully driven from below by victims, family members, social and human rights organizations, and lawyers. This is the result of the extensive and unrelenting work of an international network of human rights activists fighting against impunity for serious state crimes. The presentation before courts of these cases would be unthinkable without several people in different parts of the world putting their expertise at the service of a common outcome, ending impunity for state crimes such as genocide and crimes against humanity. Although these are not the only cases taking jurisdiction in Argentina, they show possible pathways for criminal trials. These cases continue a practice initiated by the so-called Argentine lawsuit against the crime of the Franco regime. And we have the pictures now. Filed on April 14, 2010, coinciding with the 1931 proclamation of the Second Spanish Republic. This lawsuit became an inspirational paragon for extraterritorial trials, and in some way has set a criterion for these types of criminal proceedings that serves as a reference to newer and similar criminal cases. We can now see, for example, Darío Rivas. He was querellante, a complainer from Argentina, and the lawyer Máximo Castex with Ignacio Hoptis, who nowadays is the lawyer in the case of Venezuela. So the connection exists also between the lawyers. So we can understand these facts as a socio-legal experience little known in the legal field. Its development is currently at risk given the changes in policy towards human rights set in place by the new Argentine president since December 10th, 2023. So I would like to go a bit more in depth related the cases in Argentina. This picture is related with the case of the Franco regime, and this is the building from the Supreme Court, and we can see lawyers and complainers and victims' relatives. So the lawyer, Máximo Castex, who represents the Spanish victims, affirmed that the lawsuit for the crimes of Franco's regime has been transcendent by its very existence, as it is the only criminal investigation opened for this fact in the world. Without exception, universal jurisdiction cases exist for international uninvestigated crimes in the countries where they were perpetrated, no in other jurisdiction. This particular nature of criminal cases brought under the principle of universal jurisdiction in the Argentine federal courts raises several questions, which I propose to address here. The first one is why these complaints were submitted and nowadays take place in Argentina. The second one is how these local criminal proceedings for international crimes are carried out under the principle of universal jurisdiction. So in the first case, the choice of Argentine federal justice system as a forum, the narrative sustained by the plaintiff, social and human rights organizations, as well as by their lawyers, indicates that Argentina was identified by them as a forum because of its extensive experience in dealing with justice for international crimes perpetrated during the last Argentine military dictatorship. This can be seen both in the trial of the military juntas in 1985 and in the reopening of trials for crimes against humanity in the 2000s, as well as in the trials for the appropriation of children and innovations such as the truth trial. As of June 2024, 225 sentences for crimes against humanity had been handed down, resulting in the conviction of 1,187 perpetrators. Argentina is also recognized for its role in developing international human rights treaties, such as the incorporation of the right to identity in the Convention of the Right of the Child and the promotion of the International Convention Against Enforced Disappearances. Those who have decided to file complaints in Argentina point out the prestige of human rights fights earned by the country. World recognition becomes a central factor in grounding their struggle in Argentina. This perspective translate into a positive evaluation of the Argentinian federal courts in terms of their knowledge of the nature of state crimes and their expertise to investigate these acts. These dynamics of criminal justice are linked to the existence of various state policies to promote memory, truth, and justice. Without going any further, some of the lawyers in these cases are Argentines whose trajectories demonstrate strong links with human rights, both locally and internationally. In these cases of the Latin American complaints, sharing the same continent and language is also mentioned as an advantage. To share Spanish as a language implied the reduction of obstacles for access to justice and the processing of the criminal case when, for example, transport costs are reduced, communications and work with evidence is facilitated. Although this is not a situation common to all cases, it does not reduce the possibility of applying universal jurisdiction. Another completely different case is the complaint by the Rohingya people, finally achieved when, in the second instance, the Federal Court of Appeal accepted the case regardless of the remoteness as well as cultural and linguistic differences, thus exposing a jurisprudential definition of universal jurisdiction. Another reason for the choice of Argentina in the Franco case was the migratory movement that led to relatives of victims residing in the country, as was the case of the first plaintiff, Dario Rivas, the man from the picture before, and Inés García Holgado. Migrations are highlighted by Leslie Jones, Maximo Langer, and Margaret Peters as a point that facilitates and promotes universal jurisdiction. This dynamic of mobility of people gives rise to a form of justice remittance, as John Langer and Peters have coined the concept. When migrants ultimately pressure the states where they have arrived to pursue universal jurisdiction cases. Related to the second question, universal jurisdiction proceedings in Argentina, it's important to note that Argentinian legislation allows the initiation of criminal proceedings without the need for the physical presence of the defendant in the country. This criterion of local criminal procedure facilitates the filing of criminal complaints for extraterritorial international crimes. However, this procedure facility does not have a correlation with the possibility of an oral trial, as trials in absentia are not permitted in Argentina. In theoretical terms,
may I interrupt you? I'm very sorry, but as Alejandro has to leave in 5 minutes,
okay.
I'm thinking about having a sharp break, if you permit, just to take some questions at least, or
okay, perfect. Yeah, no
is
problem.
It okay for you?
Yeah.
Okay, so we have one question in the chat by Julia. I have been told that Alejandro has already answered it in written, but only to her. So maybe take this question. I would also have a question, but also I would like to encourage you to put your questions into the chat. So Julia's question was about the subsidiarity of universal jurisdiction prosecutions and how it is applied, this criteria of subsidiarity, if indeed, as Alejandro mentioned, Argentinian prosecutors were able to put away politically uncomfortable cases, so to speak. So, for example, in the example of China that Alejandro mentioned, how was the standard of subsidiarity then applied?
Thank you. I'll keep it short and like my presentation. So this, we don't know exactly how it works on the contours of this subsidiarity principle, but the idea is that there may be a better forum for investigating these crimes. So this, I think this innovation was developed in the Mohammed bin Salman case that I mentioned, that the court, instead of saying, well, I don't have jurisdiction and going through the appeals court, or saying I do have a jurisdiction, or even Mohamed bin Salman had immunity, sovereign immunity as an incumbent minister of defense. They said, well, before we can exercise this universal jurisdiction, we have to see whether these crimes are being investigated in other jurisdictions. So they sent requests to Yemen, to Turkey, to Saudi Arabia, and to the ICC, just in case, to see whether they will be investigated. And because, of course, no one answered, they said, well, we don't know, we can't proceed, we can't be sure. And so they left the investigation there. And in the case of China, they pursued a similar strategy. So the NGOs who were bringing the cases were German and American, and so they asked the American and the German state, as well as the Chinese states, whether any of these offenses were being investigated. And because they received partial overlap between the facts being complained about, the criminal complaint in Argentina and the investigations elsewhere, they said, well, these are jurisdictions which are in a better position because not only the NGOs, but also some of the victims are already there. And so they're in a much better position. We should not investigate. This decision has gone appealed to the appeals chamber, which has confirmed this. And now the private prosecutors have requested another appeal to the Federal Cassation Court, and it's not yet sorted out, but this is the general strategy that Argentine courts have been pursuing. Of course, this is very, it's a work of legal craft. We don't know exactly how this works because it's not based on any particular provision in the Argentine legal system.
Thank you, Alberto. So it still sounds to me as if it's a very low bar then to get rid of these cases, almost a hypothetical subsidiarity, so to speak. I'm afraid, do we have time for another question to you? Or...
Yes, please.
Yes, okay. So then I would throw in my question to you, which is about the framing of universal jurisdiction cases as a part of an interventionist logic. And I wasn't sure whether you would agree with that, like naming it an interventionist logic, or whether you repeat how it is maybe perceived, because I'm not sure whether I would agree that universal jurisdiction is actually interventionist. It never takes anything away from the state, which would have a more direct link to prosecute. And they are still free to prosecute themselves, of course. There's not a monopoly of prosecutions. And so why would it actually be interventionist in this way?
Well, I think that it would be my approach to it is that it's a justified form of intervention. But I think that traditionally the principle of non-intervention has been concerned with the idea that decisions that have impact over the Latin American territory should not be made in the global north, or in Europe, or in the United States. That was the main concern. So although it does not take away anything in particular, it does make a decision concerning a political or criminal fact that has occurred in the territory of a sovereign state and decides over whether the people are responsible and whether the acts are criminal. So in a sense, it does put into question the sovereignty as an exclusive, Latin American scholars tended to favor, and some of them still do, very absolutist notions of sovereignty. And so within that framework, of course, this is a form of intervention, I would say. Now, as I said, the Argentinian case has the peculiarity that the civil society, NGOs, very influential NGOs, and many other actors in public opinion were very in favor of universal jurisdiction prosecutions in the 90s. And so that has changed the sensibility with regards to that. And now it is interesting that some of the main advocates of Argentina being a part of this universal jurisdiction business is precisely that it's a global South country, and particularly with the case of Spain, or now there's another in Ukraine against a Russian military official. It's a south-north form of universal jurisdiction, so it kind of balances this suspicion that universal jurisdiction entails some form of intervention which should be carefully assessed. Does that make any sense? So I think that's the main sensibility with regards of our intellectual trajectory concerning international law and how Latin Americans have viewed the principle of non-intervention, which is a much stronger principle than perhaps in other parts of the world.
Okay, yes, thank you very much. I'm afraid we have to let you go now. We would be so happy to delve into more questions. Thank you, Alejandro, and goodbye. And now I have to apologize again to Julieta. I've been very rude to interrupt your presentation. I know it's difficult to find back. I think one of the last points that you were speaking about was that no physical presence is needed for cases in Argentina, if I remember correctly. I hope that we can find our way back to Julieta's presentation and give her the time to finish, please.
Okay, I'm talking about cases very different to the Chinese and the Saudi Arabia case presented by Professor Käsemann before. So I'm talking about proceedings that are going on nowadays. So, well, in theoretical terms, universal jurisdiction in Argentina is similar to the concept of broad jurisdiction, given that there are no restrictions or requirements regarding any kind of national connection. This has also been a reason why some complaints has chosen Argentina as a destination. As mentioned in the examples before, the following procedural advances have been found in different cases. First, the admission of plaintiff, even with a broad concept of victim. Second, the declaration of witnesses and victims. Third, the sending of letters rogatory. Fourth, the carrying out of evidentiary measures such as exhumations in Spain. Fifth, the application of international arrest warrants. And sixth, the holding of a public inquest hearing, although so far only in the case of the Franco regime. As a central issue, while it's true that is in these cases of universal jurisdiction, it's difficult to work with evidence related to international crimes, even more so from a distance. However, it's not less complex than in ad hoc or international courts. We know that this type of international crimes itself makes it difficult to prove. By 2020, Maximo Langer and his team had counted nearly 100 individual complaints filed with the Argentinian federal justice system for international crimes under the principle of universal jurisdiction. In recent years, the number of individuals' complaints has undoubtedly increased with new cases, including, among others, those from Myanmar, Nicaragua, Venezuela, and Colombia. However, despite the years that have passed, there is no prospect of oral debate and public trials in the oldest cases in order to determine whether or not the accused are responsible for the international crimes under investigation. Herein lies the first crucial point of debate. While for some criminal lawyers, it's not possible to think of the efficiency of the criminal justice system without trials. Nevertheless, for other lawyers and even plaintiffs, the goal pursued is not an effective conviction. In the same sense, Naomi Rotariasa reflected on the Pinochet case in terms of precedents. For all this reason, it's worth recalling the author analysis. In short, she argued that the arrest of the former dictator in London allowed the veil of possibility to be lifted in Chile. This dynamic gave rise to a local Chilean movement for both historical and criminal review of past human rights violations. In this sense, the world's experience with universal jurisdictions warned of the possible legislative and executive powers' control over the complaints or the advance towards trials. In other words, the cases of Spain and Belgium demonstrate that it's possible to legislate to close the tool of universal jurisdiction. It is relevant to take into account that in these countries, this has happened after a boom in the use of this jurisdiction, having promoted high-profile and somewhat costly cases in terms of diplomatic and international relations. Langer has pointed out the relationship between politics and law, and this case is under universal jurisdiction, an issue worth bearing in mind. Lastly, for a kind of conclusions and final remarks, beyond the fact that those who support these criminal proceedings in Argentina are confident that they contribute to closing the impunity gap, the truth is that the diversity of criminal cases under universal jurisdiction in the Argentinian justice system are not free of contradictions, tensions, paradoxes, and unknowns. Some of these situations are common in this type of criminal proceedings throughout the world, but others are particular both to the Argentine reality and to the configuration of the federal Argentine judiciary, with its rules and officials, that is to say, with practices and habitus and now sociological understanding in the court space. This evident materiality of the challenges invites caution in the analysis of these criminal cases under universal jurisdiction. We need to go beyond the enchanted or romantic views. It's not possible to idealize Argentine's federal justice system. Each case has its own specificities, which is why it is not possible to generalize and think of all universal jurisdiction trials in Argentina as the same. Each case reflects particular facts and struggles in the fight against impunity, where different collective constructions emerge. Similarly, it should be borne in mind that universal jurisdiction is a tool that can be used by different groups with different political intentions. Among other cases, complaints have recently been filed over the Hamas attacks and the invasion of Ukraine. And there has yet to be a judicial resolution on these allegations. All of these are highly sensitive issues in international relations. Once again, we can not forget to raise questions about the capacity of local courts to settle matters that have an impact on the foreign policy of states. However, beyond the criticisms, one possible hypothesis is that the exercise of trials for international crimes under universal jurisdiction in Argentina can somehow keep the local flame of memory, truth, and justice alive when the current Argentine government is threatened to close this kind of policies. In other words, the promotion of extraterritorial trials can help to sustain the local process of a struggle against impunity for state crimes in the face of the attacks of the current political times. This view brings us back to rethinking the strategies for international cooperation in a struggle for justice in alliance from below. In the construction between different histories, peoples, victims, there is still a great deal of ground to be explored and conquered here. From this perspective, we can reformulate the initial question and think beyond it. These criminal proceedings under universal jurisdiction, by being alive, also encourage the fight against impunity in Argentina to continue. This continuity is relevant in the midst of difficult times in which the human rights consensus that was thought to have been achieved has been put to the test. Once again, these extraterritorial criminal proceedings in Argentina offer us a unique observation opportunity to understand both the scope and the limits of the principle of universal jurisdiction. All this is happening in a world where the promise of non-repetition of massacres and massive human rights violations is less and less fulfilled. In short, when day by day the nunca más, never again, is violated and demands some kind of answer from us. Thank you very much.
Thank you, Julieta, and my apologies again for the interruption. So time is running. I think we should, I don't see a question to Julieta in the chat. I myself have one question maybe, but then we could proceed to the second panel. So we have time for both presentations and then a comprehensive question and answers for all the speakers who are still present with us, if you agree. So maybe one question taking up something that Alejandro mentioned, and just to hear about, hear your opinion, Julieta. I was curious when Alejandro mentioned that, if I understood him correctly, cases of universal jurisdictions are being used in Argentina to, so to speak, gain political profile, public attention, which I'm not sure whether this would be the case in Germany. Maybe we can discuss that, but just to hear your opinion, is would that also be your perception? Is it actually the case that lawyers can gain so much political or public attention by pursuing these kind of cases?
I think that Alejandro mentioned that in connection with the judges and prosecutors. And in a way, I agree, because are people very controversial, the federal judiciary. So with these cases, they can wash their face as they are doing good job internationally connected with human rights, very big issues. So in that way, they bring them the opportunity to be in the newspapers and in the news as being good guys. And this is correct, I think. But there are so many aspects that are going together to have a big picture that perhaps we can talk more later, to give the floor to the second panel.
Okay, thank you. Yes, yeah, now I see there's
You're
a
welcome.
question of Julia as well. But Julia, do you want to raise this question now, or should we have it later? Later. Okay. Okay, so thanks again, Julieta. And let's proceed then to the German panel, so to speak. We have another two excellent speakers, Julia Genois and Nathalie von Wistinghausen. We plan to have Julia's perspective, an academic perspective first, and then proceed with Nathalie, who would then talk more of the practical issues. But maybe we can switch it up, Nathalie, if you are okay to go first. Would that be fine by you?
Everything's fine with me, but maybe Julia wants to set the scene with the more theoretical aspects, and I jump on with it. But for me, it's, you know, either way, it's fine.
Okay, then I think we can go first with Nathalie, and I will introduce her a little bit at least. She is, as she mentioned, a lawyer working in Berlin. She specializes in not only criminal law, but international criminal law, and has appeared as a defense lawyer before the International Criminal Court, as well as other international or internationalized courts like the ICTR and the Special Tribunal for Lebanon. She is also very active in the International Bar Association, where she has taken up different duties as a member of the Executive Council, for example, and also as a co-chair of the War Crimes Committee of the IBA. And in Germany, she has also appeared in several high-profile court cases of international crimes. Namely, she has been the leading defense counsel for a former Burgmestre, Rwandan Burgmestre, who was involved in the Rwandan genocide, who had to appear before a court in Frankfurt in Germany. And since 2019, she is also working as a representative of victims in cases of international crimes, representing Yazidi women who have been targeted by the Islamic States, as we all know. So very broad experience, Natalie, with these kinds of cases, and we are very glad and honored to have you with us today. Please, the floor is yours.
All right. Well, thank you for having me. Buenas tardes, I shall say. It's been super interesting for me to listen to the other speakers, because it reminds me of so many things and triggers thoughts. I was in Santiago de Chile in 1998 when Pinochet was arrested, and now that I'm reminded of this, I realize that maybe it's one of the reasons why it triggered my interest in this area of law, because I can remember how the discussions were so active, obviously on both sides. And I really had the feeling that it was the time that the country actually started to speak about what had happened. There had been a lot of silence before. And I think that, this aspect we should always keep in mind when we deal with different situations. And for me as a lawyer, obviously as an outsider of a country with conflict, at least during my lifetime, it's always like the first step is to try to understand what has happened historically, socially, and then to try to give it like a legal shape. I also found super interesting to hear about the Argentinian cases. I obviously knew about the cases against around the military dictatorship in Argentina, but when you see now the cases that you are mainly dealing with, being Venezuela, Colombia, Nicaragua, Myanmar may be an exception, it also shows that obviously the choice of the cases, and you have mentioned it, Giulietta, also depend a little bit on geographical, maybe historical, social, maybe also practical aspects to make these investigations successful. And so in Germany, I will just touch upon a few cases, but you will see that the choice of the cases, in my view, and everything I say obviously are just observations because I'm not part of the judiciary, but they are also very much linked to the possibilities of the Office of the General Prosecutor to bring an investigation to success. So sometimes the choice has nothing really to do with it being more justified to look at this case more than at another, but obviously they have to make choices for political reasons, for resource reasons, and the cases that came to fruition here in Germany over the past years dealt with Syrian state torture as a crime against humanity. Why? One of the reasons, because even though these are real cases of pure universal jurisdiction, we have a huge Syrian community in Germany, which makes the investigation and testimonies of witnesses as difficult as they are, but still easier and more accessible. Same for trials against members of ISIS. In these trials, I have represented Yazidi survivors. The Yazidis are a religious minority mainly from northern Iraq. And why are these trials so prominent in Germany? And we have had 8 or 9 as of today, and one more is upcoming in the next spring, is because there is also a huge Yazidi community in Germany. There has always been, but then also after the genocide, a lot of refugees were received in the south of Germany, and this allowed investigators from the federal police to speak to many of them, to collect testimonies, and, for example, to establish that there was a genocide, which historically, I think, is not in question. But of course, for a court to establish that there was a genocide, the threshold is quite high. There was also a trial against a Gambian accused of being a member of a killing squad. For example, 10 years ago, the trial that was already mentioned against my client, former Rwandan Burgomaster, for his participation in the Rwandan genocide. Why? He was arrested in Germany because he had sought asylum here. He had already lived here with his family for many years. Before he was arrested, originally on the basis of a Rwandan international arrest warrant. And yes, I spare you the details, but the Germans then started their own investigations and issued their own arrest warrant. So being the first, maybe, or maybe not the first, but like, being or taking the responsibility of having these kind of trials is, of course, not an easy thing to do. And I've been involved for, I would say a bit more than 10 years or 12 years. And of course, there's a huge development. When I compare the trial against my Rwandan client, yes, 10, 12 years ago, and the trials I see today, obviously on all sides of the protagonists, be it judges, prosecutors, victims and defense lawyers, the quality of the work being done has very much improved. And this is something that in the Rwandan trial I criticized a lot, because even though I'm, of course, a supporter of the prosecution of international crimes, but when you do it and the allegations are serious, you have to do it right. And I think there were a lot of shortcomings, certainly on the defense side, and I still see huge challenges for the defense that no one ever really talks about. But if you're facing such grave allegations and that have happened in another country, and you just have 1 or 2 lawyers to represent you and who hardly have any possibility of investigating and or any resources even to do so, that is, of course, very complicated. And why am I mentioning this? Because we have these different bodies. We are talking about universal jurisdiction, but we can't see it in isolation. Of course, we have the international tribunals, which, as we know, don't work in certain circumstances because the legal requirements are not there. But if you compare cases before the international tribunals and cases before the national tribunals, I wouldn't say that one is better than the other, but certainly if you look at the resources that defense and victims counsel have, I represent victims in the Darfur case at the ICC at the moment, the difference is huge, and that, of course, has an impact on your work and what you can do in the 24 hours a day has, and certainly the legal aid policies at the international tribunals allow for much more professional approach to these very serious cases. And again, I think, I don't want to speak about resources because that's not really interesting, but I want to talk about justice. And in my view, with the observations I have made, it makes a real difference for a suspect to be extradited or to be prosecuted before an international tribunal or before a national tribunal, because the legal framework is not that different, because we are trying to adapt, of course, on a national level to what the Rome Statute says and what the international tribunals do, and we take over some of the jurisprudence. But the setting and the possibilities, and also sometimes the threshold to prove something, is so different from an international court to a national court that sometimes I wonder, especially now that lawyers are, trying to find the right jurisdictions where to place their case, if I may say, if this doesn't have an impact actually on, yes, certainly on the rights of the accused, and in a way also on justice. This is maybe, a broader topic, but I hit my head on this very often because I can just see the huge differences. In Germany, certainly, as I said, there have been a lot of improvements, and only very recently we have had a reform of the Code Against International Crimes. This reform touched on very important issues related to victims' participation, for example, because now victims can become joint plaintiffs in a case. They can join the proceedings on the basis of being victims of international crimes, and not only by being victims of national crimes like murder, rape, and so forth. So that was a real necessity. There are a few changes in the material law. I don't want to go too much into detail, because that would be maybe just too much for this little presentation I can make, but maybe just to highlight that the Germans are trying to get as close with their legal framework to what the Rome Statute says, and the reforms touch upon, for example, sexual and gender-based violence, or the crime of disappearance, which is now easier to prosecute, which of course is a huge success, if I may say. Another topic that's of course always very important is that we are talking about crimes that have little to do with our own country, save the fact that some of the victims may live here. But of course, another country, another community, above all, another victims community is affected. And outreach is a huge problem. Outreach is part of what international tribunals do, but the national tribunals don't have the facilities to do that. It's really the civil society that supports that role, which is super important. But what has been now decided and put into our law is the translation and recording of proceedings. So that is already a huge improvement. Imagine that in the Syrian trial in Koblenz, you had people sitting in the public gallery who weren't even allowed to get a headset and to listen to the translation that was provided anyway to the witnesses and the accused. Something that's completely nonsensical, if I may say. So this is something that's now going to be provided for, and also the recording of the whole proceedings, which is not something that is yet rooted in the German law for other trials, hopefully to come, but we're not there yet. They will be recorded, and it won't be a requirement anymore that there is an outstanding contemporary significance for Germany. The significance in the past had to be connected to our country, while now a historical significance for Syria, Gambia, Iraq, or another country would suffice. So that is, of course, also a huge progress. Yeah, well, I'm not going to talk too much about this reform because Julia may do that. Another point that I have to mention again is that the rights of the accused, fair trial issues are not mentioned in this law or in the reforms. It's never part of the discussions. And I see that this is a huge challenge for the lawyers. For the victims' lawyers, something will change as well, because at the ICC, as a common legal representative of victims, I represent hundreds, thousands. In my case, I represent now 1,300 victims. Does it make sense? I'm not sure. I mean, how can I really address their views and concerns? I do my best, but it's a very difficult task. But in a way, it's acceptable because the role of the victims at the ICC is very different. It's about their views and concerns, which plays a role during the proceedings, but it's not about bringing evidence. And they certainly don't have the same procedural rights as the accused, different in a German courtroom. A victim who's a participating victim, joint plaintiff, as we call it, has very strong procedural rights, nearly the same rights as the accused. And for those to be effective, it's very difficult to represent different victims at the same time, or a group of victims. I take issue with this term at all, to talk about the victims. In my experience, and I'm sure you will say the same, every victim's story and what they've lived through, and the specificities of their suffering, be it their own suffering or the suffering of family members or the community, are very, very different. And also the expectations of victims of a trial can be very different. At least this is my observation and my experience also representing victims. And I find that very difficult, the idea to represent several victims before a German court. Given the legal tools I have, which are good, which are strong, but I don't really see how this can work, especially if it's, if we're talking about 10, 20 or 30 people. What else? I mean, there's so much to say that maybe I will stop here and focus on questions that you may have after having heard Julia, because again, there's so much to say, but maybe there's a special focus of what the audience is interested in. So yes, thanks a lot.
Thank you, Natalie. I think it's more than enough to think about, and again, encourage you to raise questions. Let's proceed then to our final speaker. It's Julia Genois, who is, of course, a member of our Memoria Legal Expert Group. She's also a professor of German and International Criminal Law, Criminal Procedural Law, and Comparative Law at the University of Bremen. She obtained her habilitation from the University of Hamburg, working together with Florian Jesberger. She also holds a PhD from Humboldt-Universität and a master's degree from the NYU School of Law. Julia is an expert on several issues of international criminal law. She focuses or her current research focuses on the relationship between several law regimes of international criminal law and counterterrorism criminal law, and the normative relationship between them. For the topic of our event today, one of her core pieces of research is her PhD in German, which focused on the exercise of prosecutorial discretion in cases of international crimes, Völkerrechtsverbrechen and Verfolgungsermessen. And Julia, please give us your input. The presentation has already started. And then, well, maybe you can also start the discussion after your presentation. You have already put one question to Julia in the chat, which I haven't read. And I have noted that you have also a question to Natalie. So please, the floor is yours.
Okay, thank you very much, Boris. So I can actually keep my presentation a bit brief, and I will kind of interestingly, so to say, give a bit of a theoretical underpinning from an academic perspective of what Nathalie von Wistinghausen has just said. So in my presentation, I want to talk a little bit about the development of universal jurisdiction in Germany, because Germany is regarded and also regards itself as a pioneer of this domestic turn in international criminal law practice in general, at least I would like to say in the European context. So in 2002, just very briefly to give you the overview of the legal framework of international criminal law in Germany, in 2002, the German Code of Crimes Against International Law, the Völkerstrafgesetzbuch, entered into force, and this code implements all crimes under international law, that is genocide, crimes against humanity, and war crimes, as well as the crime of aggression, into the domestic legal order, and it kind of provides the legal basis for the prosecution of crimes under international law by the German criminal justice system. But Nathalie von Wistinghausen already mentioned that also before the existence of the Code of Crimes Against International Law, we had a kind of German international criminal law practice. We had some proceedings that dealt with crimes under international law regarding the wars that took place in the former Yugoslavia, and also the genocide that was committed in Rwanda in the mid-1990s. But except for the crime of genocide, we didn't have a definition of international crimes. So these proceedings were based on the ordinary definition of crimes: homicide, murder, assault, rape, as I said, except for the crime of genocide. And that was one reason why we implemented, or why Germany implemented, the Code of Crimes Against International Law. And one very important feature of that Code of Crimes Against International Law is the principle of universal jurisdiction. So German prosecution authorities and German courts have the authority to prosecute international crimes, no matter where, against whom, and by whom these crimes were committed, and except for the crime of aggression. When it comes to the crime of aggression, actually, we do need a link between the crime and Germany, but for genocide, crimes against humanity, and war crimes, we have so-called absolute universal jurisdiction. And the theoretical thinking behind that is that these are crimes under international law, and these are crimes under international law because they are an attack on the fundamental interests of the international community as a whole, that is peace, security, and the well-being of the world, as it's noted in the preamble of the ICC statute. And because the international community has kind of the legitimacy to criminalize these attacks, it's also that each and every state has the right or the legitimacy to incorporate these crimes into their domestic legal order and to prosecute them even if there is no link whatsoever to the state. Alberto mentioned that in his brief introduction. And if states do so, if they use universal jurisdiction to prosecute and try international crimes, then they act as deputies or trustees or guardians of the international community. That's what it said in the academic literature. That's kind of the theoretical underpinning of universal jurisdiction. And just very brief, in Germany, we also have very broad prosecutorial discretion So apparently that's different in Argentina. In Germany, a specific section was implemented in the Code of Criminal Procedure that allows for very broad prosecutorial discretion, at least in cases that where there is no connection whatsoever between the crime and Germany. So, as Nathalie von Wistinghausen said, the prosecution authorities, the Federal Prosecutor General in Germany, who is responsible for the prosecution of international crimes in Germany, has to make choices which cases to prosecute in Germany and which ones not. So this is kind of the legal framework, and what is like the one point I would like to make, which I think is important, is that when international crimes are prosecuted under universal jurisdiction by domestic authorities, by domestic courts, then those actors they wear kind of two hats. They are, of course, still domestic prosecution authorities or domestic courts, so they act within their domestic criminal legal system, but at the same time, they are kind of elements of the system of international criminal justice. So this system of international criminal justice is kind of a multi-level system that is made up of a large number of domestic and international courts and tribunals and different other kind of criminal law institutions. Most prominently, of course, the International Criminal Court. But as I said, also states and state authorities and courts are part of that system. And so when investigations or proceedings or trials are conducted under universal jurisdiction in a state, then the prosecution authorities and the courts act within the domestic criminal legal system, but also within this system of international criminal justice. And this is sometimes referred as dédoublement fonctionnel, kind of a double functionality of those authorities. And this is important because whenever the prosecution authorities or the courts make certain decisions, if they have discretion when making their decisions, they must take that into account. They must take into account that they do not only act as domestic actors, but that they are also kind of internationalized by the subject matter they are dealing with. This is kind of the main point I would like to make. And this was also acknowledged by the German Federal Constitutional Court in a decision which goes back to the Al-Khatib trial that Nathalie von Wistinghausen mentioned. And she also mentioned the legal issue that was dealt with by the Federal Constitutional Court, namely that certain press people from Syria were not given access to the translation of the proceedings into Arabic. So they went to the Constitutional Court, and the Constitutional Court said that that is the taking into account of the public interest of a population and media representatives beyond Germany, applies all the more in the view of the fact that Germany is claiming jurisdiction, namely universal jurisdiction, that would not exist according to general principles, but that exists due to the nature of the crimes and questions that affect the international community as a whole. And this is specific, like what I just tried to explain, that the German court in this case, when making the decision whether Syrian media representatives should be given access to the translation, they need to take into account that they are not only acting within the German legal system, but they are also acting sort of within the system of international criminal justice and need to take account interests that they would not need to take account if they were acting in a pure domestic setting, so to say. Just very, very briefly on the development of ICL practice. Actually, I can more or less skip that part because we have already heard about that. So how does German international criminal law look like in practice? In the first 10 years, in the first decade after the Code of Crimes against international law entered into force, there were hardly any cases at all. That changed during the second decade. Nathalie von Wistinghausen mentioned that that is primarily due to the war, the conflict in Syria, and the migration movement, the many refugees that came to Germany, and these refugees, there were also like a large number of victims of the crimes, international crimes that were committed by the Syrian regime, but also perpetrators that fled the conflict and came to Germany. And like what I always like to do is to split the many cases we have now. We have about 50 court judgments right now dealing with international crimes. And the most part of them are cases at the intersection of counterterrorism and international criminal law. So they are very, I would say, low-key cases. They do not, there is not a lot of attention on these cases. Mostly these are members of ISIS or other jihadist groups, and they are convicted for membership in a terrorist organization, and then also for a war crime most of the times, and maybe for other ordinary crimes. And then on the other hand, we have those international criminal law cases proper, and we have heard about the Yazidi genocide cases, very important group of cases. And then the Al-Khatib trial that was already mentioned, which dealt with crimes of the Syrian regime. It was actually the first trial worldwide dealing with crimes committed by the Syrian regime. And actually, just these two issues, again, just to come back to the point I'm making, regarding like two issues that became clear in this Al-Khatib trial before the High Regional Court of Koblenz. That was the issue of access to the translation and the problem that the court did not understand that it is also acting as kind of trustee representative of the international legal community. That was then kind of corrected by the German Constitutional Court. And the second example goes into a similar direction, was also already mentioned by Nathalie von Wistinghausen, the issue of the recording of the main trial. So again, there was a petition to record the trial because of its importance. First trial worldwide dealing with the crimes of the Syrian regime. And then the preceding judge said that no, because this trial is important, but not for Germany. It might be important for the Syrian community, maybe for the international community, but not for the German, not for Germany itself. So these were like two of the problems that became visible during that trial. And then, and again, we have heard about that, the German legislator actually acknowledged these issues and acted very quickly, one must say. And enacted, or the Bundestag, the German legislature, adopted this act on the further development of international criminal law and kind of corrected both issues in the law itself. So now it's in the law that foreign media must have access to the translation, and that also it must be acknowledged that those trials that do not need to be important for Germany only, but can also be important for other communities, be it the Syrian community as kind of the victim community or the international community. Okay, I leave it at that, and I'm happy to discuss.
Thank you, Julia. So we have very few time for the discussion, actually. We have to recognize that Julia has raised two questions, and there has been also an additional question of Dorothee. Maybe let's start with the questions to Julieta. So one question is the Argentinian perspective on the ICC, because of course in Germany, when we have these prosecutions of international crimes, there's at least from the lay perspective, there's always but what about the International Criminal Court? Isn't that the best forum for doing these prosecutions? Why should we invest money and time? So what is the Argentinian perspective on the ICC more in general when it comes to burden sharing, maybe to investigate and prosecute ICL crimes? And then Dorothee's question as well comes back to the point that Julia has now mentioned in Germany, with regard to records of the trial, maybe documentation, audiovisual documentation. So are these proceedings recorded? Are there special rules in place, at least from an archival preservation of these trials? Yes, this would be two questions for Julieta, please.
Okay, thanks. I will try to be very short. I think that many things are connected with our rules of criminal proceeding that are different from Germany. So that is a point for example, and Professor Käsemann said before, that first we have two parts of the trial. First is our investigation, and it's not public. And all the proceedings under universal jurisdiction right now are under the first part, so are not public. So for me, it's also very complicated to have access to the files because it's not public. Sometimes some journalists have access to some pieces of the file, but it's not so easy, and it's not, we have no provisions about that. So this is a big issue. But the second part of the proceedings, for example, in the case of the cases of crimes against humanity in Argentina, we had a development about that. And for that reason, there were a kind of agreements with public institutions like the National Institute of Cinema and national universities to make records of the audience in the second part of the trial, the debate, the oral debate, and the oral debate is public. So the big issue with the universal jurisdiction cases in Argentina is that we are very far away to this second stage of the trial. So we have no good news related to public stage. So nowadays, no access to public files or nothing. So we have no public information, no public hearings, nothing at this stage. So in the future, we don't know. Hopefully, we will have some public stage, but we don't know right now. And then the question about the ICC is very interesting. So thanks for that also. But for example, and again, we have a different proceeding. So we have the private prosecution, which presented the complaint. So we have victims' lawyers presenting the complaints for the international criminal, for international crimes. So in this case, then the prosecutor and the judge decided if the allegations have jurisdiction or not to go further in the Argentine jurisdiction. So the decision is not made by an state institution. So the decision to present a complaint is made by a private lawyer, a victim's lawyer. So, but nevertheless, however, the case of Myanmar, the Rohingya people in Myanmar, it's not possible to have this case into the ICC because Myanmar is not part of the Rome Institute. And we know all the complexities to have another way to address the jurisdiction in the ICC. And the case of Venezuela and Colombia, there were started a kind of investigations under the ICC, but finally they were closed. So this jurisdiction is not available right now. And in the case of Colombia, it was a decision to came to Argentina related to some points that Natalie pointed out before. The issue of the to be in the same continent, the same language, Spanish, and also due an issue of resources. It's much cheaper to bring a case into Argentina than in the ICC. But this is very, very in short. I don't know if it's enough, my answer to Julia, but we can continue later in other moment. Thanks.
Okay, yes, thank you very much, Julieta. Maybe Julia, you can either say to Julieta whether you would like to have more details on your question, but you also had a question to Natalie, if I'm correct, and maybe just raise that question directly to Natalie, please.
Okay, thank you, Boris. Thank you, Julieta. That was very interesting. So very much to think about. But I have a question to Natalie von Wistinghausen, because it's always like super interesting for me that you kind of know both sides of those universal jurisdiction trials. And I don't mean the international side and the domestic side, but also the victim side and the defendant side. And so I was just interested what you think about, I don't know how to frame it, but this kind of activist use of universal jurisdiction, or the use by victims of universal jurisdiction. As, for example, Alejandro said that universal jurisdiction has this communicative force, and it's true, and that universal jurisdiction proceedings are important even if there are no trials for victims to tell their story. Yes, I get that, but I mean, they are still criminal trials against specific defendants with the aim of like charging them and, you know, putting them to prison, maybe. So I'm just wondering how you feel about this use of universal jurisdiction.
This opens like a really big topic, but look, I think we're all on the same page that we support accountability for international crimes. Nothing, you know, I mean, nothing to add. For me, and I know that this may not sound very popular, at the heart of the criminal proceedings, you still have the accused, right? And then depending on the jurisdictions, you will have victims' participation. At the ad hoc tribunals, for example, you didn't have victims' participation. And that, of course, changes a lot the dynamic of the proceedings. Until 2019, I've only been on the defense side. And of course, my view on things has changed a little bit since I'm representing victims in these kind of proceedings, because I understand, or I saw, and it's a reality, that without the representation of these victims, be it individuals or the community, there would be no cases. At least not in Germany. All the cases are being brought by civil society organizations, NGOs. It's impossible for the office of the general prosecutor to do these investigations. In many instances, they cannot even travel to the country we are talking about. They haven't been to Syria, they haven't been to Iraq, and it took them a long time before they set a foot to Rwanda. So that's also a reality that you know, if you want accountability for these crimes, you need the evidence, you need the testimony of the witnesses. And in these trials, be it before the international or the national trials, the most important evidence, even though it's complicated evidence, is still witness testimony. And in the Yazidi trials where I represented the victims, it's our clients who provided the crucial evidence. Without them being identified on the ground by an NGO, being brought to Germany and be in the courtroom and testify and tell their story, there may have been an indictment, but in my view, you know, a conviction wouldn't have been possible. There are some ISIS trials where, you know, social media evidence could be enough, and some telecommunication evidence, and so on and so forth. But of course, you know, the witness testimony is crucial. So I have to say they're a bit two hearts are beating in my breast, because I take issue with this forum shopping. I also take issue with the competition between NGOs. I find that insupportable, as you say in French, right? Because I just don't think it's right. The cooperation also, this is just an observation as an outsider, but I find that difficult to bear. Because if you take it seriously, then you know, it's not a question of business and reputation and all the rest. It's really serious. And of course, sometimes, and I know I get on people's nerves with that, but I would like to see NGOs or human rights activists to take care of the rights of the accused as well, and to see that they get the support that they require. And I'm just going to give you food for thought when you go home. Look at acquittals in universal jurisdiction cases in Germany. There is none. Look at decisions at the ICC and the ad hoc tribunals, and you will see that the decisions are, you can agree or disagree with them, but at least you will have a serious possibility of getting out of there. And we are not moral instances as lawyers. You know, for me, it's not what I think, you know, if a person is guilty or not. You know, it's about evidence. And yes, and I'm observing this, and I think it's an issue.
Thank you very much, Natalie. Very thought-provoking, of course. I mean, we are past 7 p.m. German time. There's one last question by Alberto to Julia. Maybe, Alberto, you just chime in directly and raise the question to Julia. We need your audio.
Thank you, Boris, and thank you for the patience of hearing this last comment. It is related with the question that you have done to Julia, because you said in which way in Argentina is regarded the ICC. And as a matter of fact, in the last decision concerning the Maduro case, the judge of the first instance, the investigating judge, decided to refuse his competence because a matter related with Venezuela was investigated by the ICC. But then the Chamber of Appeal revoked that decision and said, no, doesn't matter, you should investigate this. Well, my question was to you, if Section 153, talking generally about international tribunal, will produce the same effect. I mean, any kind of investigation going on in the ICC will stop and a claim before a German tribunal?
So it's a bit complicated because it depends a lot on the specific facts. But in general, I would say, or in general, it is that there is also a principle of subsidiarity. So whenever the ICC has a case, then German courts, then the German prosecutor should exercise the discretion in a way to close or not to open proceedings. Should there is it's not an obligation to close the case, but it's kind of a nudge to close the case. But if it's a kind of a different case, so different facts, I would say then there is discretion. There is still discretion whether to open a case or not. So the discretion is not limited in a way to close the proceedings. Yeah, it's a very complicated norm, actually.
Okay, thank you, Alberto. Thank you, Julia. And I'm looking, well, into digital faces, but yeah, I think we have reached the end of our event of today. Let me thank again to all the speakers. Alejandro had to leave early, Julieta, Natalie, and Julia, of course. And thanks to all the participants who have stayed with us. I mean, unsurprisingly, we haven't solved all the issues and questions around universal jurisdictions today, but I guess what we have experienced again is that how valuable the exchange between Argentina and Germany, between Latin America, Europe, Global South, Global North, is when it comes to discussing problems of international criminal law. And this, of course, lies right at the center of our Memoria Legal Expert Group. This is our conviction and aspiration that indeed this exchange of perspectives is very valuable. And so we hope to see you again for the third Memoria Talk. Date is not set yet. Yeah, enjoy your afternoon or evening in Germany, whether it is cold as it is in Argentina apparently, or very hot as it is in Germany. Thank you to all of us. I'm looking around. Dorothee, Natalia, is there anything left to say? No?
That's very well said, Boris. Well, I should only shortly close this event. Many thanks to the speakers, to the audience, to our group, Memoria Working Legal Group. Thank you, Dorothee, for giving us the space at the foundation, at the Elisabeth Käsemann Foundation, to talk about Memoria. So thank you very much, everybody, for being here today. Have a nice afternoon/evening.
Thanks a lot for having me. Bye.
Thanks. See you soon.